Greetings, this is Dr. Della Welch. Today we're going to talk about sales law, S-A-L-E-S. Sales law pertains to UCC Article 2, and it has been adopted in 49 of the states. It has not been adopted in Louisiana. The Uniform Commercial Code, Article 2, applies to commercial transactions. The big transaction is a sale, and a sale is a transfer of title for a price. It also applies to leases, but that is UCC 2A and not Article 2. So it applies to, UCC 2 applies to sale of goods or transactions in goods. Goods are anything tangible and movable. It is personal property and not real property and not services. And it is not intangibles such as money or stocks, insurance policies, and other intangibles. So sometime there's an issue. Suppose you get a permanent wave and it causes your hair to fall out. Well, what caused it? What was the predominant factor? Was it the service? Was it Hercules working that day and pulled your hair out? In which case, it would be a service that was defective. However, if the permanent wave made every other customer go bald and you were the unlucky one, then the predominant factor would be the goods, and you could bring a suit under the Uniform Commercial Code, Article 2. Now, some of the provisions of the code require someone to be a merchant. A merchant is one who ordinarily deals in goods of a particular kind, or who holds himself out to a higher standard than customers or consumers. So, for example, suppose I get tired of being an attorney and I want to open a hat shop. And my first day on the job as a hat shop owner, let's say someone gets injured, a pin sticks them and they bleed or something. Well, I would be considered a merchant as to hats. Now, under the Uniform Commercial Code, there's more freedom than under ordinary contract law. Terms that are missing, we can say, right, they're open terms. If no price, the market price at the time of delivery. Or if no date or location, then you deliver in a reasonable time and exchange at the seller's location. So we're not quite so tight as we were in contract law in terms of sales law. Now, one of the big differences is UCC Article 2-207. And this is where there is an added term. Let's say that Merchant A has a used car and he wants to sell it to Merchant B for $400. Well, both parties have to be merchants. Let's say that B adds a term and says, okay, I'll pay you the price that you asked for, but you must deliver the car polished and waxed. Well, that's an added term. Does it automatically come in as part of the contract? Well, we must do our analysis. Are both parties merchants? Yes. Is the added term no big deal or immaterial? Yes, to deliver a car polished and waxed would be a very minor term if you're in the car business. And then, was there any notification of objection to the added term? No, there wasn't. So what's happening here is the added term automatically comes in unless there's an objection. Now, one of the things you need to remember is that if we have a contract under the statute of frauds under the UCC, it need not contain all of the terms. If there's a good that costs over $500 or more, then we must have a writing. If the parties are talking on the phone and one party is a merchant and either of the parties send a confirmatory memorandum of the terms, then the parties are bound. So we see some very important differences under the contract law and also under the Uniform Commercial Code law.